Hello and welcome to Bangalore International Centre's very own podcast, BIC Talks. Bangalore International Centre is a platform for informed conversations, exchange of ideas, and a space for arts and culture. BIC Talks brings the essence of all that the physical space stands for and more to your doorstep.
Justice Frustrated, The Systematic Impact of Delays in Indian Courts is the latest edited book by Harish Narasappa, Shruthi Vidyasagar and Shruthi Naik. Harish Narasappa is a noted lawyer and partner at Samvad Partners and is the co-founder of Daksh India. Welcome to BIC Talks, Harish.
Thank you, Pawan. Pleasure to be here.
And talking to Harish today about the book is Sarayu Natarajan, host of the Ganatantra podcast and founder of the Apti Institute. Sarayu, welcome and over to you.
Thank you, Pawan. It's a pleasure to be here. Harish, it's great to meet you again.
Same here, Sarayu.
I want to start actually by congratulating you on this fantastic compilation of essays. It was a very, very interesting read. For the listeners, this provides a fantastic framework within which to understand judicial delays, to understand both the concept and the ways in which it affects the system. The book very effectively dimensionalizes the implications of delay on various institutions as well as various types of litigants. And I think that is the most important part of this book. For this conversation, I'm going to structure it as two things that hopefully we will explore with Harish. One is talking a little bit more about the concepts in the book to understand from a structural level. So both I, for sure, but also the listeners get an understanding of how and why judicial delays come to bear and also the effects they have on the system at large. And also talk a little bit more about solutions and answers that we can begin to think about to pass through this problem and respond to this concern. So Harish, one thing I'd love to understand is why this book now? Why the topic of judicial delays? Why this set of authors? So if you could talk us through a little bit more about the motivations of the topic and the timing, would love to hear.
Sure. So actually, this is our third book in the series that Daksh has worked on. So Daksh has been focusing on what we call the Rule of Law project. The primary feature of the project is the studying of the delays in the judicial system. And this is the third in the series of the books that we have brought out pursuant to that work that we are doing. The reason why we started producing these books was because Daksh had started collecting a lot of data which gave insights into the minute reasons for delays in the judicial system in India. And we thought that using the data, we should have people write about different aspects of the delays. Because data, is only talking about numbers, but numbers have a meaning. And we wanted, experts who can understand the data to write about it in a manner that is easily accessible to everyone outside the judicial system as well. So to better understand what delay means and what can be done about these delays. So there's no specific reason for the timing of the book. It's just that, it was ready and we released it now. And we hope to continue doing this. So we will be releasing a few more books in the series. Like, for example, the first book was all about understanding data around the Indian judiciary and delays as such. The second book, focused more on access to justice and the different pathways to justice. And this is the third book where we have looked at different aspects of judicial delay, the different impacts that it has in society.
Harish, I'd love for you to talk a little bit more about this question of delay itself. What does it mean and why is it called a judicial delay? Is it a reference just to this site where the delay occurs? And your book talks about it in great length, especially the first section about the various sort of institutional actors and factors that are responsible for some of what we see manifested as delay. But would love for you to explore that question a little bit more, like how does a delay become a delay in a certain way?
I'll take your question in two parts. One, what does delay mean and why is it relevant? Two, is it judicial delay or is it delay of the system? For example, some people call it laws delays and not just judicial delays. So in Daksh, we have looked at delays of the judicial system. And when we talk about judicial system, it's not just the judges and judiciary, but also, for example, the police when we're dealing with criminal justice system and other institutions that form part of the justice system. Right? So judicial delay encompasses the whole thing. So in our judiciary, there are two broad wings, right? One is that the part of the system that deals with disputes between individuals. It could be civil disputes, it could be criminal disputes, but it deals with disputes between the citizens. The second is the disputes that it deals between the citizens and the state. Now, each of this, the natural progression of any dispute through a judicial system has an optimal time for settlement. Because at the core of any dispute are rights and obligations. Every citizen has different sets of rights, and you go to court only because these rights have been violated. And you go to court seeking redressal of such violation. Now, if that redressal happens within a time-bound frame, that is when justice is actually delivered. If the resolution of this violation of your rights happens 10 years or 12 years after you go to court, then the very meaning of redressal of that right is lost. So that is why the important thing is redressal of a violation has to not only be done in terms of substantively, but also has to be done within a meaningful time. For example, if something is not redressed for a year or 6 months or sometimes even a couple of days, the redressal itself becomes meaningless. That is why when the system takes a long time or beyond what it should take, then delays are relevant, and delays go to the core of any society that seeks to be governed by law. If you do not redress the violation of rights in a meaningful and time-bound fashion, then there are questions about following the law itself. And that is why this is an important issue. If you do not implement the law, and what you're doing is actually implementation when you're enforcing your rights, if you do not implement the law in a meaningful, proper and time-bound fashion, then the law itself loses relevance and the whole legal system loses relevance. So that's why delays are so critical for any judicial system and at large for any society that seeks to be governed by law.
Right, and I think that's really the point also that the book makes in a certain way, which is to build from the consequences on individuals or litigants in their quest for articulating their rights, but also the systemic costs. And I think you make this very interesting argument in your essay around the possibility that these kinds of delays in the system actually reward negative behavior. I think you use the analogy of Trishanku. As for those who might not be familiar, this is a king from Indian mythology that was permanently stuck between heaven and earth, and as an analogy to describe some of the challenges around understanding delay and sort of measuring its impact. So I'd love for you to talk a little bit more about this.
Let me take a minute, Sarayu, to explain, when I talk about rewarding illegality and not protecting legality. So if you go to court complaining about an illegality that somebody has conducted, and you do not get a redressal of that within a meaningful time frame. And if you look at my essay, since you referred to my essay, I give various examples of actual cases from the Indian judicial system that took 20 years, 30 years to be resolved, and explain that while the case is pending, it is for the judicial system, it's just a number. It's a case number in the system. But for the people involved in the case, their life outside the case continues. For example, the behavior that you complained about, the consequences of that behavior continue unabated. Correct? Now, when the courts take 5 years or 10 years or 15 years to decide a particular case, they fail to realize that the consequences of the action that is being sought to be redressed before the court actually continue, and those consequences don't stop. Now, that is what we need to recognize. When you fail to stop the consequences within a reasonable time frame, that means the person who has committed the wrong actually does not suffer the consequences of his wrong. So he actually benefits from it because he is able to enjoy either the fruits of his illegal actions, or others who he intended to suffer from his illegal actions actually continue to suffer. So if you do not actually do the one thing you're supposed to do, which is redress the wrong committed and protect the rights, then what you're essentially doing is putting the person who has committed the wrong and the person who suffers from the wrong on the same footing. And there is no benefit to following the law. And this is a crucial factor even when we look at Indian legal system as a whole. We should take simple things like traffic rules, right? And I love this example of traffic rules. What is the punishment that we are able to give to a person who breaks or who jumps a red signal? Our enforcement mechanisms are so poor that a person who breaks the red signal, he actually gains, right? And why have we created these traffic signals? We have created traffic signals and traffic rules so that it benefits everybody, so that there's an orderly movement of traffic within the city. But when somebody jumps a traffic signal, he's actually trying to get somewhere faster. If he doesn't get caught or asked to follow the rules, then he benefits from that. Whereas a person who is following the rules doesn't actually benefit from the fact that he's following the rules, right? So we're creating this, or rather, we're equating legality and illegality. That's one of the consequences of the failure to decide cases on time. And that's what I seek to explain.
Right, absolutely. And I think, and this, a couple of the other essays in the book later pick it up as well. This attains significance in a magnified way in some other context. So there is individual consequences and individual reward and individual punishment for illegality. So it begins to get into the question of even rule of law, not just rights. But particularly in certain disputes like electoral disputes, labor disputes, or disputes with corporations, when these rewards are reaped for a longer period of time while the case is being decided, then there is a societal cost as well.
Yes, and we need to recognize that. And what we forget at times is we think that institutions have an end to themselves, right? And while it is true that the existence of certain institutions in society have a purpose, their very existence has sends out a message and has a role. The more important thing is the purpose they serve in society. And when we forget that main purpose and what you are supposed to do, and don't examine the consequences of certain actions or inactions of the institution, then the institution also loses relevance, right? And that is what most of the other authors also, and most of the essays in this book try to talk about, that while judicial delay or delays of cases within the judicial system is looked upon as a problem in itself, somehow people think it affects only the judicial system and not others in society or other aspects in society. But what you are essentially doing is leaving people in the lurch and leaving them in this state of uncertainty, which is what is very harmful to different people in diverse sectors. Like there are in this collection, there are people who have looked at trafficking, human trafficking. There are authors who have looked at economic consequences. There are authors who have looked at labor problems. So all of these are different aspects, and it has a very wide-ranging impact. And I agree with you. I think it's an extremely diverse range of impacts and consequences.
Right, and very many of them, by in some ways calling it as judicial delay, you tend to think of it as something that occurs only in the court system. But to your point, and as this book amply demonstrates, there are consequences across a range of factors and some very insidious because they're not really visible. And they're particularly insidious when they're intersected with certain types of social marginalities. You yourself just brought up a couple of essays that talk about human trafficking, transgender and intersex persons. I think there are a couple of essays about that. I'd love to talk about this a little bit more, actually. The idea of the subjectivity in the experience of delay and how it intersects with economic hardships and social marginalities. Because, setting aside institutions as litigants, individuals as litigants, the personhood and that subjective experience of citizenship matters a lot. And there's a whole bunch of evidence across domains that sheds light on this experience, particularly gender, particularly economic, class, caste, etc. So I'd love for you to talk more about these subjective consequences and the way you've dealt with it in your book as integrating or sort of speaking to the concept of rule of law and articulation of rights.
Yeah, no, I'm just thinking where to start because it's such a loaded question, right? There's so many. There are so many.
It's a whole lot.
Yeah, there are so many, facets to the question that you asked. Let me try to answer this in a simple fashion, right? And that is that when you're dealing with cases, you're actually dealing with human beings. And I made this point a bit earlier as well. And we assume that somehow the case that is being contested in the judicial system is divorced from the rest of that human being and his or her social and economic situation and his or her social and economic activities, right? And I think that is the fault lines of the legal system when we don't try to address cases and conclude them in a time-bound fashion. We just take that case and say, okay, we will decide this. Everything else is irrelevant. And to some extent, it is good because a judge is supposed to be impartial. He's supposed to look at the facts of the case and decide. The surrounding circumstances of each individual before him doesn't really matter to how he decides the case. Yes, he may consider some of the circumstances, when he is providing relief, right? But he looks at the judge, he or she only looks at the facts of the case on hand and doesn't look at the other surrounding circumstances. It's the other surrounding circumstances that we are talking about, correct? And in each different case, the impact of the case on the surrounding circumstances could be either marginal or could be direct and substantial. One from the criminal side and one from the civil side to contrast and to highlight the consequences. This is actually a story that I heard. I shouldn't call it a story. It's a case of which I was told about by a lawyer friend. That here was a security guard who was performing his duties in a factory that was manufacturing electronic devices, and this is in one of the states in North India. The security guard was from Nepal. He was a Nepali citizen, and one day there was a theft in the factory, and some goods were lost, and most of the goods were recovered, but there was goods worth some 5,000 rupees that was lost. Now, after investigation, the police found that this individual had facilitated the stealing of these devices by turning a blind eye, right? He just looked the other way. He knew who these guys were. Now, he was arrested and his bail was set at X amount of rupees. I think the lawyer told me it was about 5,000 rupees. Now, the bail was 5,000 rupees. The value of the goods lost was 5,000 rupees. And here was a person who was not from that area. Now, he was unable to produce bail because he was not able to generate the 5,000 rupees. Nor did he have any local citizen that is within that area who was willing to come and stand bail for it. So he continued to languish in jail for more than 5 years. Now, there was a family that was dependent on him for whatever little money he was sending. Now, what is a judge supposed to do and what is the law supposed to do? And what are the consequences on this individual and the family that was dependent on him and his meager income? So these are the things that we forget to look at. And this is here the case, I mean, he's in jail, so it is not a marginal impact on him. It's a complete impact. His liberty has been deprived. Not only that, the impact on his family is severe. And for what? For a marginal amount that has been lost, for which, nobody is actually grieving for that marginal amount. And yes, in theory, he's abetted a crime, so he has to be punished for it and all of that. That's correct. But how far does the punishment go? And the reality is, he's never been punished because the case is still going on and is in jail. And this, I think, highlights all I suppose I didn't answer your question directly, but by giving the facts, I'm bringing out the different facets, right? So that's the first example. Now, if we take a civil case, and this again is a case, a plot of a 30-40 site on which bought by the father, and then the sons start fighting for it as to who owns the property. Now, if one son doesn't have any other income and is dependent on the rent that is coming, this property, and if the case takes 10 years and the rent is, while the case is pending, the rent is deposited in court and not given to the individuals, then the financial impact on these people, while they are, conducting their lives otherwise, but the financial impact on them is significant. At the same time, if you take a very large company, then the impact may be marginal. So for the people who are otherwise already economically, at a disadvantage or socially at a disadvantage, the impact of delay, particularly in a case where the facts of the case are such that your entire livelihood revolves around those facts, then the impact becomes much more severe and crippling. So that is the points I think we have tried to highlight, whether it is economic, social, or other aspects in society. The impact of the failure of the judicial system to resolve things quickly is more on marginalized people, whether economic, social, or otherwise.
Right, and this is compounded by the experience of the system itself, which is inaccessible because of the power structure and language. So that in fact magnifies in a certain way the impact of delay for various communities, and especially those that experience social or economic discrimination. Harish, I'd love to switch tracks now a little bit to start talking about the solutions. And I think the book does talk a little bit about it, and it sort of dismantles this notion of judge strength. So increasing the number of judges or increasing capacity for decision making in a numerical way. So could you talk a little bit more about that and break down this argument for us? Like, why is it not just about judge strength? So if you just increased a double capacity, would the rate of decision making correspondingly double?
Unfortunately, the answer is no. I'll take the last part. If you just double the number of judges, it's not as if the disposal rate will double immediately. And, two of my colleagues from Daksh, Surya and Siddharth Mandrik Rao actually have done a data analysis when a new court was established in a district, whether that led to, disposal rates being increased and the time coming down. They've done a detailed study. And again, I'll explain why. What we do when we look at this problem is we look at the big picture. We look at the overall picture, right? We say, okay, why is it taking 5 years? Why are 3 crore cases pending in the system? And these are all the questions that the media houses cover. And this is also, unfortunately, what the policymakers focus on. They say, oh, numbers have to come down. But what we are dealing with when we're dealing with the system is we are dealing with people in the system and we're dealing with their daily efficiencies or inefficiencies. Okay. Now, why does a case go on for 5 years, or why are 3 crore cases pending? We have to break it down and come down to each day in court. Unless and until we make each day in court more efficient, you're not going to solve the bigger problem, because it is daily inefficiencies that add up to the number in terms of days and the number in terms of cases. If if each day, so let's take a simple example, right? On an average, so in terms of district courts, there are about 18,000 or so. It's about 17,500, but it's around 18,000 judges, district judges in the country today. The sanction strength is 21,000, but there are vacancies of about 2,500. So it's always varies between 17.5 to 18.5. So there are about that many district judges in the country. And on top of that, there are about 1,000 odd high court judges, and there are about 30 judges in the Supreme Court. Now, but the majority of the cases are at the district level. So on an average, there are between 60 to 90 cases listed before each district judge every day across the country. Now, if 60 cases are listed, and I'm taking the lower end of the number, and this is the average again for those of, for some data geeks, there are some judges before whom only 20 comes, but this is the average. If you take all the 18,000 judges, is an average between 60 to 90, and even that average is fairly wide, as you can see. I'm saying the range is 60 to 90. Now, in court, a judge spends between 5 to 6 hours in court, okay, on an average. Now, in those 5 to 6 hours, he has to go through these 60 to 90 cases that are listed. Some of them take just a minute. Some of them take a few hours. Now, it is humanly impossible to go through all of them. It's not possible because you have, a 5-hour working day in court, and then you have about 60. So, on any given day, it is guaranteed that at least half of the cases, and I'm being very, very conservative, at least half of the cases go to some other day. And when that another day is being given, there is also uncertainty about whether the case will go on for the purpose for which it has been listed on the next day, because nobody knows what that day looks like. And here, it is not just the judge that is the reason. It is a lawyer, the 2 lawyers who are involved in the case, the police who may be giving evidence, there could be forensic evidence that is being given, there could be doctors who are coming, or there could be individuals themselves, individual who are supposed to give evidence could not get leave or could not travel, something like that, right? So there's a lot of uncertainty about whether a case will proceed or not. And unless we tackle this uncertainty, we will not be able to resolve this problem. While judge numbers will help, because as a country, we do not have sufficient number of judges. And there is a debate about that. Historically, people said we're very, very understaffed. We need to, double, triple the number of judges. But now the thinking has evolved, and recently general consensus is that given the number of cases that are being filed in the system, we are not so bad off when it comes to the number of judges. And the optimal, number of judges we need is probably only about 2x to what we have, and that too in a staggered fashion. And in fact, a committee called the NCMS has presented a detailed paper which the Supreme Court has accepted about how to evolve judge strength. So it is not as if, about 20 years ago, somebody said, oh, we need to quadruple the number of judges we have. That is not the situation. But the reasons I gave, unless we fix these inefficiencies in how each case proceeds every day, just doubling the number of judges or quadrupling the number of judges is not going to help. What you will do is double or quadruple the number of inefficiencies also. Another thing we should also remember is when you say double the number of judges, it's not just putting and recruiting judges, it's also the support staff, right? And the entire mechanism. A judge is just he's the most important player in the system, but there are other equally important cogs to move things forward. So it is not so easy to just increase the number of judges. And as I said, there are already about 2,000 vacancies in the system. And just filling these vacancies itself will improve things a little bit. But the fundamental thing is to improve the uncertainty around the event. So when this uncertainty moves towards certainty in as many cases as possible each day, then we will be able to solve the problem.
That's a fascinating point. Now I would like to talk a little bit about the role technology may be able to play here. There is an essay in the book that talks about the use of technology, particularly for the government to manage its disputes. And the government is a very big litigant in the court system, as you yourself point out in some sections of the book. But what is the role for technology? Because the conversation seems to be on two tracks. There is the track around technology playing a role in addressing certain inefficiencies and breakdowns, either through redressing process issues or communication issues. And then there's the second parallel conversation on the role of artificial intelligence and machine learning and the role it can play in either addressing systemic issues in terms of delays or other sort of aspects of challenges with the court system. So would love for you to reflect a little bit more on where the opportunities for technology are and therefore what could also be the harms of it.
So technology has a big role to play. Okay, on that there is no doubt, but not artificial intelligence and machine learning and all. I'm afraid our legal system is at a far more basic level. I don't think we have reached a stage where we can use AI or machine learning. And anyway, I think AI and machine learning is being bandied about too much when it comes to the judiciary as such. And in fact, lawyers as such, I mean, people are saying, oh, can AI replace judges? Can AI, substitute a judgment and all of that? I think those are all, sort of far, far away. So I won't even talk about that.
Thank you for dismantling that.
But I think, just in terms of technology playing a role, I think it has a significant role. I'll explain why. Some of the processes that our legal system currently follows were designed more than 100 years ago. And we don't need to follow those processes. For example, how to serve summons, and that every piece of paper has to be printed on some green sheets in a long form, peculiar format, all of that, right? And there are many such quirky processes. Most things are still written in hand. While the e-court system has made a significant improvement in digitizing the process, what has happened is there has been no thought given to reimagining some of the processes using new technology that is available. And that needs to happen. In fact, what has happened is, while there's been a massive push on digitizing the judiciary, they have simply replicated the paper processes that existed earlier. So what you have today is the judicial system not only following the paper processes, on top of the paper processes, they just record it on the computer. So it has actually become more inefficient. And if you talk to people within the system, they say, sir, our work has actually doubled after the e-court system was implemented. Initially, I was intrigued and I said, why? He said, earlier, I only had to maintain a paper register. Now, not only do I have to maintain a paper register, I also have to make sure that it is uploaded onto the system later. So I spend more time than what I used to do earlier. So that is what has happened. And that is because you just said, okay, let's computerize the whole system. You did not say, let's look at the processes and make it more efficient. And the two are significantly different decisions that need to be taken, right? Now, actually, there is a move to reimagine the judicial processes. So even when I say reimagine the judicial processes, there are some things that has to be done by the legislature, new laws have to be passed. But just even in terms of the daily processes that the judiciary follows, which is not necessarily legislated, but it is more practice rules that the courts have formed for themselves, those have to be reimagined for a tech world. And again, I will take a simple example. Like one of the things is in the process was if you produced a photograph, you had to also produce an original. So we go back to the era before mobile phones and digital photographs. You had an original, so you had the negative, and then you did a print, and then you could photocopy that. Now, with digital cameras, what is the original photograph? But even now, when I produce a photograph in court, if it's from a digital camera, I print it and produce a photograph, there is an office objection raised saying the original has not been produced. So these are the kind of processes that need to be reimagined to ensure that we benefit from technology. The answer to your question, yes, technology is absolutely important and it can be used in terms of, I earlier talked about uncertainty. Technology can be used to create more certainty. For example, intelligent scheduling of cases. Why should there be 60 cases? Why not 25? And what are those 25? So figuring out schedules, calendars, optimization of a judge's time, optimization of time in court, all these are things where technology can play an important role, even in terms of access to justice. And I think this pandemic has opened the eyes of the legal system to the possibilities of remote access to courts. And hopefully they will learn from this. Yes, there have been some teething problems, but hopefully they'll learn from this and make this a feature which enables access to justice and improves the efficiencies.
So, I'd like to stay with this question of access to justice, Harish, a little bit and talk about an emergent area, which is online dispute resolution, which is now being spoken about as potentially a solution to certain categories of disputes that might already exist in the judicial system. So, it's spoken of in the context of unclogging, it's spoken of in the context of a range of new and emergent disputes, like with the emergence of social commerce, etc. So, I'd love for you to talk about online dispute resolution a little bit more, specifically dwelling on this question of access, going back to what the book talks about in terms of how the question of access to justice itself is complicated by who you are. And so if you introduce a layer of technology in this process, what does that mean for questions of exclusion, specifically focusing on ODR?
So I think in terms of ODR itself, again, unfortunately, it's a phrase that we all seem to love to use without quite understanding what it is all about and what it can do. So ODR is certainly an idea that has come in terms of using online tools to enable resolution of disputes in a more efficient fashion. But what we should remember is ODR is just a tool. You still need people to manage the tool, and you still need people to resolve the disputes. That is, if you take traditional areas that have plagued the legal system, like a criminal case or even a civil dispute, you can't imagine a criminal case being resolved through ODR means. Yes, you can use certain forms of technology to enable resolution, but you can't use that. Where ODR has made progress is, for example, in extremely low value commercial cases, extremely low value consumer cases. There have been good examples of ODR being used to resolve those disputes. I also believe personally, and I'm involved with an ODR institution. I also believe personally that ODR can help in terms of mediation and arbitration and avoiding of disputes through sort of alternate dispute resolution methods. Mediation and arbitration being the most prominent of those. And I think there is a good opportunity to do those. But I do not think that it will have a great impact on the judicial delays as such in the country, in India, because the two are at the moment, the way they are operating at the moment, the way they are two separate worlds and they intersect at very few points. Right? The kind of cases that go to ODR are not cases that have traditionally gone to the judiciary as such. So there have been disputes that the legal system has not been able to resolve through the extremely formal methods of dispute resolution. That's why these dispute resolutions have become popular. So that's where ODR has become useful, at least that's the experience of other countries. But I think there's an enormous opportunity to use that as an access to justice tool. But it requires a lot of imagination and reimagination, where the ODR tool needs to be customized for our country so that it can be used by someone, say in a taluk headquarters or in a gram panchayat headquarters. So you need to be able to customize these tools. Now, and merely developing a ODR platform is not going to do that. You have to develop some amount of ecosystem for that, where you can create better access to justice on some of the issues that have plagued the system. It certainly can't be used immediately to help the criminal justice system. You can use ODR to help people become more aware of rights and all of that. But to resolve a criminal dispute, it will be very difficult. But to resolve many civil disputes, it's possible to take ODR to district levels, taluk levels, but that requires a lot of imagination and a lot of investment, both in terms of people and in terms of technology. And that, I think, has a long way to go. But where it is certainly helpful is in terms of consumer disputes and other sorts of family disputes. You can use ODR to resolve some of these disputes. I think it is certainly an idea whose time has come, but it needs to be tested properly in our country.
Thank you for saying that, because one big concern that when we look into questions of the role of technology in various spaces, is that the assumption is there's no variation or no differentiation in the type of dispute or the type of concern, and that technology presents a universal stick or like it's a silver bullet of sorts that you can use in a varying range of situations. But that's not actually the case, as you yourself pointed out. So, Harish, to conclude, I think would love to hear if you had any final thoughts on this, and also reflect on what next and how this book can contribute to the various conversations that are ongoing on judicial delay and how to build from there.
Sure. Just to clarify on the technology, I don't know whether I sounded a bit pessimistic about technology and ODR earlier. I mean, to the contrary, I'm a big believer in technology and ODR. I just believe that there needs to be a lot of thinking where you tailor the systems in such a fashion that helps, some of the problems that we are facing, rather than assuming that the silver bullet solution as we all think of, because it's not a silver bullet. I mean, it is some.
Absolutely. Absolutely. And you need to consider, I think, like very many of the essays point out, right, that there's a very subjective experience. Different people have different concerns. And each dispute also has its own nature and trajectory. So you need to pay attention to that before you to adapt the system, rather than just automatically assuming it can apply uniformly.
That's correct. And having said that, many disputes, while there's always a distinguishing feature in terms of facts. Certain kinds of dispute, particularly consumer disputes of a certain kind, the principles are pretty much the same. The nature of the dispute is more or less uniform. So there are certain areas where things like ODR and technology will be useful. And even, things like AI may be useful in those areas. But in certain other kinds of cases, there's still a long way to go. So that's to clarify what I meant. Now, in terms of concluding thoughts and what next? So there are two aspects to what next. One, we need more and more reflections of this sort to crack this problem. It is a problem, and we need to recognize that. And we need to recognize that it is a problem not just for the judiciary as an institution, but for society as a whole. So this problem needs to be studied and attacked from different perspectives. Unfortunately, we haven't done that too much in this country. The burden of resolving this issue of delays has also been left to the judiciary itself. The leadership in the judiciary is actually quite busy dealing with the day-to-day problems and is not able to focus on the larger policy and systemic issues. So there needs to be more of such studies by many others, and not just Daksh, by many others, to solve this problem and unravel the complexity. So we need more of that. We need more champions within the judiciary itself, people who can spare time to reflect on this issue and how to tackle this. Unless we do that, we won't be able to address it. The second aspect is to actually try and carry out some pilots to implement some solutions. And again, I think, unfortunately, what we have fallen into is this trap of, writing reports after reports. And on delays itself, there have been many reports written in this country. Very few of them actually see implementation in some form or the other. So what we need actually, the time is for an empowered action committee, to implement some of these solutions. And this has to be done at a district and state level rather than a national level, because we have to experiment with different solutions in different parts of the country. Otherwise, to look for one solution that is to be imposed from Delhi or from some other center, if we keep searching for that search will be never ending. So different high courts have to take the leadership and allow different districts to experiment with small things, small changes, which allows some solutions to be thrown up. And some courts actually led the way. In Delhi, there was a pilot. It was called a zero court pilot project, and which showed a lot of valuable lessons as to how to move things forward. Similarly, in now there are for traffic offences, there are some virtual courts being done. So small examples are popping up. We need more and more of these. So we need to find ways to create some room for executing some of these suggestions. Only then will we be able to find a way forward.
Right, these are absolutely wonderful points. Thank you for those thoughts. And I think this book, in that sense, is very timely. It lays out not just a differentiated understanding of experiences and the impact, but also begins to point towards ways in which solutions can start to be imagined. But thank you so much, Harish. This engagement was at a conceptual level, not just the specifics of the book. And so this should give a frame for thinking about what the empirical learnings in the books are. But shout out to all listeners, please go ahead, get this book, because it will tell you a lot about the way question of delay in the judicial system needs to be understood. It's not just about one aspect of either judge capacity or court capacity, but one that has systemic causes and also systemic implication.
Harish, Sarayu, thank you so much for joining us on BIC Talks. This was an absolute pleasure.
Thank you.
Thank you.
Thank you for listening in till the end. Please share this episode with a friend on social media, WhatsApp, or anywhere else. It would mean the world to us. And in case you're listening via iTunes or Apple Podcasts, please leave us a rating and a review. Subscribe to BIC Talks on email or your favorite podcast app and don't miss out on future episodes. This episode of BIC Talks has Gaurav Krishna as our sound engineer, with support from S. Sarvanaraj and Lekha Naidu. And the accompanying episode artwork was made by Chandni Venkataraman.
Thank you for listening to this episode of BIC Talks. This podcast can be accessed on our website, bangaloreinternationalcenter.org, as well as on any of your favorite podcast platforms. Tune in for new episodes every week, and do subscribe to our YouTube channel and follow our Facebook, Twitter, and Instagram pages to stay informed on our latest updates.